Any mention?
Please, Your Lordship, I beg to mention item number 15 of the hearing list, my Lord.
Number?
15.
We have objection, Lordship. Let it come, Lordship. I'm praying, Lordship.
Who?
Item number 15, Lordship. We have an objection, Lordship.
Who's
I'm
come?
praying. 15. Item number 15. My learned
What's
senior is
happened
praying,
is,
Lordship.
I had a favorable order from the learned single judge of the Bombay High Court. That order was set aside by the Honorable Division Bench. Now, while it was pending before the Division Bench, they had sought time. What we are saying is that we are challenging that order of the Division Bench before the Honorable Supreme Court by filing an SLP. That is underway. We're just praying for some time. Now, you'll keep in mind that they had sought time all throughout. When this matter was pending before the Division Bench.
What is the issue here is this, Millets. They had come for registration of the Millets brand here in Meghalaya. Your Lordships would recollect. So there's an order passed by the Commissioner saying that there is some litigation pending before the Bombay.
They can't register the brand.
My Lords.
Yes.
Appeal was preferred before the Bombay, the Board of Revenue. Now the Board of Revenue, Millets, without disturbing the finding of the learned Commissioner, simply said that there is a proceeding pending. Now we had a Millets injunction order that was challenged by them before the Division Bench, and there was also a reference before the full bench. Now the reference has been answered, and the Division Bench has passed a speaking order in my favor.
In Bombay.
So insofar as that list is concerned, the injunction has been made absolute till disposal of the suit. My learned friend says, they're challenging before the Supreme Court. No grievance with that.
Produce those.
We have copies of those. I'll just place it before my lords.
You've placed it already.
Mr. Sen, are you
I am aware of this.
in the know about these orders? They are in your possession.
Your Lordship.
What I'm humbly submitting before your Lordship says that in case they succeed before the Honorable Supreme Court,
The registration will be registered.
then they'll have to make a fresh application. Because the facts of the matters will not change, because on the date on which the application
Register
was
your brand now, right?
I'm sorry, Millets.
Register your brand now.
I'm already registered. I'm all over the country, Millets.
Yes. Or except here.
No, even in Meghalaya, we're there.
Is a brand on sale?
Yes.
Then what's
Mansion
the
House
difficulty?
Brandy and Mansion House Whiskey and Millets, there are two brands that they're available in the market.
Is such a thing as Mansion House whiskey also?
Earlier it was just brandy, now they've come up with whiskey, Millets.
I'm just praying for 3 weeks' time, my Lord. After that, if they insist on a hearing, I'll take instructions.
Now let's see the operative part.
If I may just draw your Lordship's attention to the last page.
Conclusion.
If my Lords kindly have a look at page 82, paragraph 99.
Yes.
The conspectus of the above discussion is that the first impugned order dated 22nd December 2011 deserves to be upheld. This is the injunction in my favor,
Yes.
Since we have held that the first impugned order did not accept UTO's claim, that's theirs, of reversion of title, the findings of reversion of title in favor of UTO recorded in the second impugned order also needs to be aligned with the finding in the first impugned order. Also, the resultant status in the Indian market prevailing for the last 14 years after passing of the first impugned order need not be disturbed and needs to be preserved till the suit is decided. Because I was in the market, they were not. So this is the finding. For this purpose, the second impugned order will have to be set aside. We accordingly order as follows. Judgment and order dated 22 December 2011 passed in notice of motion number so-and-so is upheld and consequently appeal number so-and-so filed by UTO is dismissed. Judgment and order dated 7 February 2025 passed in notice of motion number so-and-so and counterclaim number so-and-so and passed in interim application number so-and-so set aside. That's the order in their favor. Number 3, UTO and ABD shall continue the current status of non-introduction of their products in India under the impugned marks Mansion House and Savoy Club till
So you
decision
can't
of
see
the
their brands.
They, UTO is they, not me.
UTO is a
Parent company.
They are UTO.
You're allied.
I am allied blenders.
But UTO and ABD shall continue the current status of non-introduction.
I am Tilak Nagar. I am Tilak Nagar. They are UTO.
Okay.
No, I'm allied blenders.
Allied.
No, he's allied beverages.
I'm allied.
Allied blenders.
Blenders.
Allied blenders.
Blenders. The learned trial judge is requested to expedite. I'm instructed,
So
that
the
the
suit is still
proceeding.
pending. Suit is still pending.
So what I'm submitting is,
20 years.
I'm sorry, Millets. What I'm submitting is that in case Millets they succeed before the Honorable Supreme Court, that will give them a new cause of action to file an application for introduction of the products in Meghalaya. Insofar as Millets the impugned order is concerned, it'll be the file.
I can file.
I'll just place the two orders, Millets, which are impugned before my lords.
Why then? Then we'll have a date.
Lordship, just give me 3 weeks' time, my Lord. I'll take instructions in the
My lords,
meantime.
may I pray? I am under some pressure because of this order. If my lords,
You said the products are selling in Meghalaya.
my lords.
So what is the urgency?
No,
Exactly.
my issue is this, my lords.
You are under the impression that your products are allowed to be registered?
No, I am already registered in Meghalaya. They are seeking registration. Now, what I'm submitting before my lords is if my friend wants instructions, very well, let him have instructions. My lords, today we are on the 13th. If my lords fix a date on maybe the 26th or the 27th, he can seek instructions, and my lords, if any SLP is to be filed, they will file it and they'll produce
2 weeks may be insufficient. I don't want to come back and renew a prayer for an injunction, for an adjournment. Kindly have it a week thereafter. My lord.
You expect they get a federal orders? And
No, my lords, I'm not saying that. My lords. But I'm just saying this is an interlocutory application.
If the situation changes, you have to come with another
Fresh application.
Not necessarily. I'm disputing this, my lord. I'm disputing this. I don't necessarily need to come back with
point out, my lords, what is the order. I'll just point out what is the order. Volume 3, if my lords kindly have. Volume of? Your petition.
No, it's good.
Page 462. Oh, they don't have it in volume, sorry. Page 462. Paragraph 15, my lords. That's the original order of the commissioner.
Yes.
Para 15, my lords, have it, my lords. After hearing the submissions of both the parties and on perusal of the documents submitted and the respective parties annex their reply and counter-reply, it emerges that the claim of ownership of the proprietorship of Trademark Mansion House and Savoy Club between these two parties are sub judice in appropriate courts of law, and the rights over ownership and proprietorship over the aforesaid trademark is yet to be adjudicated by the competent court of law. Therefore, I can clearly see that the claims and counterclaims are in dispute, and any finding upon such claim and counterclaim may cause prejudice to either side of the parties. Therefore, on proper examination of the issue, I have arrived at my findings that the suit for claim and counterclaims over the trademark for the said brand in question for the purpose of registration in the state of Meghalaya under so-and-so is still sub judice and yet to be adjudicated, and as such, this office regrets to consider the application of the party, that is Messrs. Allied Blenders and Distillers Private Limited, for the registration of the brand Mansion House.
So all along your brand was being sold. You're selling it.
My lords, that's the finding of the Bombay High Court. Now, the Board of Revenue, my lords, simply says there is no infirmity with this order, we're not going to touch it.
Yes.
My lords may have it, my lords.
Can you have it on the third
It is submitted with the parties that the matter pending for the Bombay High Court has since been
disposed of.
This is matter on
Third,
on 26.
No, but it'll be a little difficult for us. We'll take proper instructions. Third.
To allow the counsel for the respondent.
I'm for the petitioner.
Oh, for the petitioner.
Yeah,
Oh, sorry.
respondents 1 to 3.
To obtain proper instructions.
My lords may make this as part of the record, my lords, the
Yes,
judgment.
the order passed by the Bombay High Court in appeal number 66,012 is taken on board and made part of the record. Appeal number 66,012, other connected matters, is taken on board and made part of the record. Yes.
So, Lordship will happen on the 3rd of September.
3rd September.
Third.
Oblige.
My lord, I beg to mention item number 20, Lordship.
Number?
Number 20. There is a title suit. It's on the verge of completion, actually.
Oh, yeah, the same one. But oh, yes, what happened? It's fixed for orders, for judgment.
For judgment, again,
When, today?
no, again, it's fixed on 8 September.
Which court is this?
This is Tura, Lordship.
Which court? When was the fixed for judgment last?
It's for fixed on 13th of this month,
It was fixed on 13th of
this month. And then
August. Today it has passed judgment.
no, not yet. Not yet.
No, it's fixed today for judgment.
No. Again, it's fixed on 8 September.
8th of
Today
September.
was passed.
No, it was passed on 13.
13th this month today.
Today's 13.
Today's 30.
Today's 13.
Which court is pending?
The Court of Assistant to DC, Lordship, if I'm not mistaken.
After the Commissioner.
Lordship, in the Court of Assistant to Deputy Commissioner, Tura.
Yes.
Actually, it was fixed on 7
7 August.
7 August. Yes.
Yes, submitted by the parties, the counsel of the parties that though the title suit which is connected to the matter had been fixed for judgment on 7th of August 2025 by the court of the Assistant Deputy Commissioner West Garavils, Tura. The same has been refixed on 8th of September. according to this matter on 9th. On 10th. 10th is a working day. Yes, on 10th to await any outcome. Yes.
All right.
My lord, item number 13, my lord, Dr. Vidyadharan versus Nehu. I am for the petitioner.
30.
13, 1-3, my lord. My lord, I'm praying this matter can be fixed on the first week of September, my lord, so that I can complete my instruction and prepare it, my lord.
What's there to prepare?
The case, my lord, because the matter is fixed for hearing.
The person wrote a complaint to the High Court.
Yeah, it is his, with his knowledge, my lord, that we are taking time, my
Yes,
lord.
otherwise, he's blaming the court also, I think.
Yes, my lord, that is very unfortunate, my
But
lord.
he doesn't know this because of the councils only.
My lord.
Or else we'll take it up today itself. What is there?
No, my lord, I need to complete the instruction from him, and then I also need to prepare because I am the second in council, my lord. The first council, they was not interested to take up the matter, so he has engaged me, my lord.
Okay, after
First week of September, my lord. Hello, bless.
Make it quick, yes.
Please, Your Lordship. Lordship, I beg to mention item number 12, Your Lordship. 12, Your Lordship.
On behalf of whom?
On behalf of the petitioner. Pray for 2 weeks.
Petitioner,
I'm appearing on behalf of the respondent number 3, Your
Answer
Lordship.
the state, my lord.
3 is whom? Bank.
MIDC.
No objection.
No objection, Your Lordship.
You are
He's the
paying
one
for-
who's agreed. She's with me, Your Lordship.
2 weeks, yes.
Much obliged, Your Lordship.
Obliged, Your Lordship.
Please, Lordship, I beg to mention item 19.
Petitioner. No objection.
I'm praying for 2 weeks' time, Lordship.
Why?
Lordship, the conducting council has some personal difficulty.
Who's the current counsel?
Miss Arkashi.
Yes, 2 weeks.
Lordship.
Lordship.
Call out.
Supplementary list item number 1.
My lord, this is the second petition we filed. One case is pending before the court number 4. In fact, what happened, we challenged the impunity order passed by the authority, inflicting a minor punishment, and subsequently we prefer appeal. And appellate authority imposed a major penalty. And upon that, my lord, he has filed a revision before the higher authorities. Before revision authorities disposed of that matter, this first petition was filed. And during the pendency of the first petition, revision authority has disposed of that revision
The other
petition.
representatives become infructuous.
My lord, it is connected.
We'll post it for the other court then.
Yes, my lord.
Yes, what's the name, what's the number?
My lord. Is that 85 or 22?
8522.
My lord.
Mr. H.L. Chanreso at the outset has submitted that incident petitioner has also filed an earlier petition relating to his service, which is pending for his court, being LPC number 85 of 2022. Stop. He further submits that as the matters connected to this be listed before the bench where the other case is pending. Stop. Next, Param Dr. N. SGI will so does not dispute this submission. Accordingly, this is matter before
Court number 4.
court number 4, wherein WBC number 85 and 22 is pending consideration.
Thank you.
Yes.
Item number 2.
Please, we had to make a mention of this matter because of a peculiar circumstance. Now, what had happened in this, Millets, that the petitioner has, Millets, challenged the clubbing of, Millets, the ST and the OST and SC category in that 5% of the reservation policy. Very well, Millets, that's a policy decision of the state. I appear for MPSC. Now, the difficulty is, Millets, he has also filed a complaint with the National Commission for Scheduled Castes. Now, while this Honorable Court is seized of the matter, Millets, we are receiving, Millets, notices from the National Commission for Scheduled Castes insofar as contesting the matter there is concerned. So, Millets, my humble submission before your Lordships is that the petitioner was then have to choose, Millets, if he's approached this Honorable Court.
Why you file a complaint also?
So let my learned senior finish. I'll address it with it.
Well, if it is an issue of my lord's policy, there is a challenge before this honourable court, and my lords are hearing this entire matter. Now, I file a supplementary affidavit if my lords kindly have a look at it. Court master, supplementary affidavit. It's filed.
That is 24/7.
Valid. August, my lords.
No, it's not on board.
My lords may have it at the end of the board then.
Yes.
If we file the affidavit, it's coming.
Have we received?
But fine.
I am not on the merits of the matter, my lords. My difficulty is, my lords, that the matter is being heard by my lords, while, my lords, now the National Commission is also pursuing the same issue.
Yes, Mr. Sen, why?
No, it's not the same issue. What is under challenge here is some part of the reservation policy. That is not what is under challenge before the commission.
What do you challenge the commission?
It was a mere complaint, Willis. I have the complaint before your lordships. And it's not that I have concealed this fact.
No, I'm
before
not saying
approaching this
it's
honourable court, I filed a complaint before the commission saying that I was denied a placement. Now, at best, the MPSC can write a letter, or for that matter, I can write a letter informing them that I've already preferred a writ petition before this honourable court and the matter may be kept in abeyance.
If that is the submission coming from my learned friend, my lords, I have no grievance. Your lordships may pass an order.
Lordships may pass an order. I have no difficulty with that.
But let us see your affidavit.
My lords.
That's a common record.
Oh, we have just included the notice that we've received, my lords. To that limited extent, that is why the reason for this mention.
Yes.
Highly obliged.
The yield is item number 1.
May it please, Lordship. Lordship, the application has been filed by the petitioner seeking permission to withdraw the instant petition, my lord.
Where's the application?
Not filed.
Why you reach out of court settlement?
My lord,
the petitioner went to graze in the greener pasture. So now
Which is reported to the Supreme Court because they have mediation in action going on right now.
So, my lord, the political matters, your lordship is aware, my lord.
Where's the miss case?
Yeah.
It has not come.
It is not on record, probably.
no, we have not filed any applications to my.
Who has filed application for?
I have received one.
Just show me, because we are not aware. We are the
My lord,
You are-
I have been assigned to file the application, my lord, for withdrawal of the writ petition, my lord.
No, we are not aware of this, my lord.
My lord, it is in the process, my lord. If lordship can have it little later, my lord.
Sometime.
My lord.
Item number 2.
Near Dr. Malika.
No, this is the matter with regard to election of Headman, my lord. District Council, ready? My lord, we have come before Lordship, my lord, challenging the order dated 9th May 25.
Have some quiet, please. I'm getting a lot of, to the microphone, I'm getting a lot of feedback from the conversations going on. Yes.
Page 45 is the impugned order. my lord.
Yes.
And I'll just take your lordship to the operative part, my lord, to page 47.
Yes.
Para 1, my lord, subpara 1. As discussed, we decide thus, clause 4 of the notification number so and so, which disqualifies individuals on the ground of acting or litigating against the HEMA is one of the criteria of qualification to contest the election for the post of headman is considered to have been inserted or incorporated arbitrarily, illegally, and with the sole intent to exclude or bar the appellant from filing his nomination paper as one of the candidates for the post of headman. And as such, it is treated as null and void ab initio and against the provisions of the United Khasi Jayanti so and so 1959 as amended, as well as relevant provisions of the Khasi Autonomous District Maflang Linguistic Act 2023, which comes into force on, it's supposed to be.
Has it come to force? When has it came to force?
2025.
It has not been notified. When did you receive assent of the governor?
21st March 2025.
You sure about that?
Yes.
21st
March 25.
It's been notified.
Yes.
Came to force on 21/3/25. We can record that. Okay. Yes.
Para 2, the election conducted on 18/3/25 is declared null and void. 3, the respondent number 1 shall conduct fresh election within 2 weeks from the date of the order in accordance with the relevant provisions of the KHTC. So and so. 23. The date of election will be communicated to the Elaka Department Khasil KHTC for necessary deputation of an observer. Later copies will be submitted to the Registrar Honorable High Court of Meghalaya for information.
Yes.
My lord, the actual background of the case, my lord. My lord, if I may take your lordship to page 20.
Yes.
This was on 31st August 22 for public notification. This is to notify all general public in Hima Maflang and the village of Mongop Kleshnong that Sri Khamborlang Kharshanti has been removed from the post of headman of the Mongop Kleshnong village, and in his place Mintri R.L. Solia has been appointed as the caretaker of the village, that is the village of Mongop Kleshnong. Now, my lord, thereafter elections were declared, my lord. And Annexure 2, 23/2/24 is the order, my lord. Annexure 2.
Yes.
My lord, that may not be so relevant, my lord, because the proceedings were pending for district council. The next order, my lord, is 16/12/24. If I just take a lordship to this order.
Yes.
Cooperative part at page 28, my lord.
Yes.
This court, therefore, to bring a quietus to the issue and to ensure that the customary democratic process is adhered to, more so in recognition of the fact that respondent number 2, Lingdo, has expressed his difficulty, direct the respondent number 1 as per section 7(3) of the Act of 1959 to initiate the process and conduct the election to the post of headman of Mongop Kleshnong. The same should preferably conducted within a period of 1 month from the date of copy of this order is presented before the respondent number 1. The respondent number 2 is also directed to cooperate with the district council on the conduct of the election. The performer of respondent number 4 in the meanwhile shall remit all the necessary documents, keys and other materials to the office of headman as a designated officer.
That means this one number 4 is the one who was removed.
My lord. No. This one number 4 is the link dominant in this order. No. Come, ex-headman, my lord. Now, my lord.
Number 4 is ex-headman.
Ex-headman.
That's written here.
My lord.
Yes.
Now, my lord, the next order, your lordship will see at page 29.
Yes. Yes.
This is before the filed an appeal, my lord. Now the appeal was disposed of as follows, my lord. I'll just take your lordship to para 15, my lord.
Yes.
Accordingly, this appeal is allowed to the extent that the operation of the impugned order as directed at para 6 is hereby modified to read as follows: that the election to the post of headman Mongop Kleshnong is to be conducted by the chief and his darbar appellant hearing in accordance with section 7(1) of the said Act of 1959. The same is to be conducted within 1 month of receipt of certified copy of this order. As agreed to by the parties, in the meantime, during the process of election, the necessary documents, key and other material of the headman, which are now in possession of respondent number 1, herein are to be handed over to the secretary of the executive KHD, who will keep the same in safe position.
Yes.
So, my lord, basically, in place of district council, my lord, the chief was directed to conduct the election. Next order, my lord.
How many petitions would one matter?
My lord, there are several, my lord.
Yes.
Next order is on the writ petition of The earlier respondent, ex-Headman, my lord.
That is Hambarlang Kharsandi.
My lord. Page 35, my lord. This is order date 18/2/25.
Yes.
I read this order, my lord.
Yes.
Para 2, my lord. HR Nath, learned counsel, is present and accept notice on so and so. The grievance of the writ petitioner who is stated to be the ex-Headman of Mongop Kleshnong under Maflang's Lingdosip is with a condition that have been let down with regard to eligibility to contest for the office of Headman of the said village. Mr. So-and-so, learned counsel for the petitioner, has drawn the attention of this court to the condition dated 16/2/25, wherein a point number 4 thereof, it has been let down that a person who has acted or litigated against the HIMA cannot contest for the position of Rangbashnong. This he submits is against all norms of election process and has been inserted in the condition just to make the petitioner ineligible to contest for the said post. It is further submitted that he has received the said condition only on 14/2/25 itself on the date of the nomination, and as the illegality being writ large in the entire process, some appropriate orders may be passed in this regard. Mr. Kinta, learned senior counsel, so-and-so, has submitted that the election for the Sardar of Mongop Kleshnong under Maflang Lingdosip is being held today, and the voting has commenced since 8 a.m. in this morning. At this stage, no relief will be available to the writ petitioner before this court, and it is still, and if he still aggrieved, he can file an election petition before the respondent number 3. Para 7, my lord. Having heard the learned counsel for the parties and considering the situation at hand, it is noted that condition which is referred to by the learned counsel or the petitioners prima facie militate against the free and fair election process. However, at this stage, without making further observation in view of the fact that elections are already in progress, and to conclude by evening, it is provided that the result of the said election shall not be declared until the next date and shall keep in a sealed cover by an officer to be deputed within 1 hour today itself by the secretary so-and-so.
Then what will happen after that?
Now, my lord, thereafter the writ petition was disposed of, my lord. Page 41 of Lordship kindly come. Page 41, my lord. Annexure 7.
Yes. Yes.
I'll read this order, my lord.
Yes.
Mr. So-and-so, counsel has entered appearance today on behalf of respondent number 2 election committee as such notices so-and-so. Mr. T.T. Dingdo, learned senior counsel, stated by so-and-so, on behalf of the respondent number 3, has submitted that as per the provision of the Act, my lord, any grievance against the order of the chief, an appeal is first to be put before the executive committee KHDC. In the instant case, he submits that the dispute is with regard to the rejection of nomination of the writ petitioner by chief or for contesting the post of Rangbashnong, and as such, this instant writ petition was filed before this court, perhaps due to urgency instead of approaching the respondent number 3. Mr. Nath submits that the evidence affidavit has been filed. Having considered the matter on the submission and perusal of the material as placed, it is noted that the instant matter was taken up by this court on 18/2/25 in view of the fact that the election to the post of Headman Rangbashnong of Mongop Kleshnong was scheduled on 18/2/25 itself, and on the ground that irreparable injury be caused to the writ petitioner who was debarred from contesting the same, this court had passed the interim order keeping the election results in sealed cover and under the custody of the respondent number 3 for the time being. Today, as this matter hangs in balance and in view of other development, this court deems it a fit case to remand the case same to the adjudicated by the respondent number 3 executive committee KHDC, who shall, after hearing the parties, pass appropriate orders thereon after taking all relevant facts into consideration. The writ petitioner is therefore directed to approach the respondent number 3 with a proper political appeal, and after due notice, the respondent number 3 shall dispose of the matter in accordance with law. It is further provided that till further orders are passed by the respondent number 3, the results of the election shall be kept in abeyance. The writ petitioner shall file the appeal within a period of 1 week from today, and the parties shall be put to notice to appeal thereafter in the next 2 weeks. So that's how the writ petition was disposed of, my lord.
So what is wrong with that order?
Now, my lord.
What do you want today?
My lord, what do we want is, my lord, that
shunt him out and declare results.
My lord, we pleaded, my lord, the respondent number 4 was removed from the office, my lord, in 2020.
Number 2, yeah.
Respondent number 4.
Number 4 is writ petitioner and 2 writ petitions, correct? Mr. Lingdo. Who is number 5 here?
I'm number 5, your lordship here.
Who's Lingdo? Who Lingdo? You ready with the matter? Yes. Yes.
Now, my lord, he was removed from the office, my lord, on the allegation of diversion of some money received from our grid corporation, my lord, and to the extent of 84 lakh rupees. And a person who has just been removed, my lord, just 2 years back from the office, and that order is at end finality. can he be allowed to participate in the election?
But has he been convicted of any offence that he's been debarred from? The allegations are still just allegations, correct?
Well, allegation has attained finality. He has been removed, my lord. There is no further proceeding taken up by him against his removal, my lord.
Has he said that, yes, I've taken the money?
But, my lord, the removal order has attained finality, my lord. The removal order
So
dated.
once a person remove, you mean, where's the custom that he can't contest for this traditional, this elections anymore? You have to show that. If even a person from jail can contest, normal elections, election for headman, just see the condition that they agree with is that the only condition was put that any person who has acted against, where's the condition? And where's that condition that
It is there.
Yes, page 40. Any persons acted against or has litigated against the HIMA can contest for the position of Vaishnav. This is Adong HIMA part 1, part 7 duties. Where's this? Where's this Adong HIMA? Part 1, page 7 duties on Vaishnav. Where's it? Where is it?
That is not on record, my lord. But this notification.
If you're going by this, if that's the only stand that he has gone against the HIMA or against the village, and this is as per this Adong means strictures or directives or rules. Where's that? Yeah, with you, Adong HIMA.
Lordship,
sure.
Lordship, kindly come to.
Or not you? I mean, who's appearing for Lingdoa? You have the Adong HIMA song you have? Let us see. Part 1. Was this examined by the executive committee?
Yes, Lordship.
It was examined?
Yes.
This is a finding on this?
Yes, yes.
Adong also, where is that?
Para 46, Lordship. Last,
46?
Page 46. Last paragraph.
Last
paragraph, page 46.
Yes.
Lordship, in our opinion, this clause 4 shall form part and parcel of the Adong part 1, which outlines the general duties and responsibilities of the Rang Vaishnav. But on perusal of the Adong, we fail to find such criteria, and nowhere does it disqualify a resident from contesting based on legal litigation against the HIMA.
See, it's not only about litigation. It says that this Adong Shnong says if you are to elect as per custom, and this custom demands such that a person, where's that? Page 40.
Page 40. Has acted
against.
Yes.
How do you interpret this custom?
Well, diversion of fund, my lord. In para 2 of my writ petition, we pleaded very clearly.
I mean, then why you have not annexed this also in your writ petition? If this was part of the, this is a reason for them allowing him to contest elections. Your writ petition is incomplete.
Well, they can bring on record this.
How to bring on record? It's
we,
to bring on record.
We didn't have a copy of it.
See, it says out here, if you read it, you can see page 7, duties around Vaishnav. He cannot misuse the funds. He must work with the public. He has to dispose of the matter. Let there be fresh elections, then let him contest.
My lord, what I would pray, my lord, even if lordship directs for fresh election, my lord, because in terms of the rules, my lord, if I may just take it lordship to the rules. I've annexed at page 51, my lord.
Rules of Moplang?
No, my lord, this is a 1959 rules. Page 59, we quoted page 51, your lordship kindly sees, my lord.
Yes.
Section 8, my lord. Qualification for the office of Headman. Pending making of rules as provided under section 3, the chief and his darbar shall determine the clan or clans that can set up candidate for the office of Headman, the qualifications of a person eligible for the office of Headman, and the manner in which Headman shall be selected. So the chief has this power, my lord, to prescribe the qualifications also. And
the chief supporting your case?
My lord, I am one of the candidates who contested election, my lord.
Are you agreeable with the case of the petitioner?
Without prejudice.
My only submission on behalf of the respondent number 4 is that, Your Lordship, we have removed respondent number 5,
yes.
Respondent number 5, after giving him due notice, after we have detected some anomalies which we have done by passing our authority, by issuing NOC to the power grid. And that's why the power grid also has bypassed us, and the money was released to him. Later on, when we have filed the RTI, we have found through the RTI that he has received into his own account amount of rupees 85 lakhs plus. And thereafter, we have given him several notice to explain that this fact. 3 notices we have issued. He never responded. Thereafter, on his request, he has asked us on the 31st 8th of 2020. 22 or 23, Your Lordship, he has asked us to appear, and on that date we have asked him to bring all the documents pertaining to the village, everything. Instructions was given to him, but on that day when he came, he never brought all those documents.
Okay, then you removed him.
Thereafter, the Darbar Hima, in his presence and also the presence of the then executive committee, then the resolution was passed and he was removed.
No, only one thing I want to know. So after he removed, as per custom, that means he's not allowed to contest anymore for Headman.
Your Lordship, that's
the only thing that has been determined.
Yeah. Your Lordship, thereafter he never challenged that removal order, and thereafter he has his actions has prompted us, even Your Lordship, to approach this honourable court to file a writ petition for that our authority has been taken over. And that was the first writ petition which we have filed, making the power grid and the other respondents, the state respondents, and even the respondent number 5 to with regard to the compensation, because our compensation also with regard to the certain stretch was not paid. After we have filed this writ, Your Honor, Your Lordship, sorry, the respondent number, the state respondent has released, pending the disposal, has released that amount
to you,
to me, recognizing my authority thereafter. Thereafter, they have filed the respondent number 5.
No, the thing is that if I remember correctly, now he went by way of proxy litigation.
Yes, well.
He filed 2 writ petitions by some entities and also to challenging his removal. So that's besides the point. But only court concerned now, this order of the district council of the respondent 1, 2, and 3 says that this stricture is it is not deprive the respondent number 5 is right.
Yes, Your Lordship.
So you only have to satisfy that because all elections are held in accordance with custom.
Yes.
Correct?
Yes, sir.
In accordance with custom prevalent in that ilaka, prevalent in that raj, whatever. Now you have to show that it is as part of the custom that a person who has been removed or who has acted against the lingdorship or who has done these acts of operation is no longer eligible to contest. That's the only thing. If you can satisfy this court on that point, then we will ask for them to, we will set aside this order and let the result be declared.
Yes, Your Lordship.
Yes, but you have to satisfy first, and Mr. Lingdo also will have his say as to why he should be allowed to contest elections.
In that case, Your Lordship, may kindly give me some time to.
I think you'll need some time because even Mr. Torm was not prepared with the custom. Yes.
I can satisfy Your Lordship.
Your Lordship, may I? Lordship, most of the proceedings conducted by the Lingdo against me, those were all prior to filing of the present writ. It was only at the stage when I prefer my political appeal before the respondent, HADC, that I was supplied.
Political appeal here, affidavit, the one you
no,
filed
Your
before
Lordship.
Is not there.
No, but Your Lordship,
you bring it on record.
Most of the copies which I was entitled when I was removed, I was not supplied with any order or with anything, Your Lordship. Everything was done behind my back. I was only supplied at a stage when the hearing before the KHDC was done, Your Lordship. At first instance, that was the moment that I knew everything about the proceedings against me.
You mean to say that what has been submitted, that you appeared, you came forward, you didn't bring any documents to show that what you've done is correct? Everything is done, without hearing you.
I was present, Lordship, in one of the proceedings only. But when I was removed, Lordship, the removal...
Given adequate opportunity to present, to your case.
Lordship, opportunity for removal was not about my removal at first instance, Lordship. It was always about the money, the compensation. And even at this present proceeding as well, Lordship, it revolves around that money.
In this
the compensation. Lordship, in the affidavit also they have mentioned in the reply, and even in the pleading of the main petition as well, Your Lordship.
That is a condition that is because he acted against.
Yes, Your Lordship, but the entire matter.
If they say that's already been, if accepted, that that you took the money, you put in your account.
No, Your Lordship, the entire matter was discussed, Lordship, in petition number 296 of 2023. I have filed my affidavit, Lordship.
Have the file also?
Yes, we have.
Who are the counsel?
No, we don't know.
What's your stand?
Lordship, our stand.
Your stand says it's a bad custom. This adong shnong.
Yes.
It's a bad custom.
Yes.
Was that argued? That is why is a good custom or bad custom?
Lordship, we have dealt this matter that whether the election process is in accordance with the customary law and relevant provision of the...
So your finding is not in accordance with the custom. No. And so the not allowing him to contest against is not as part of the custom. He should be allowed to contest.
Yes. We have directed that
then we'll have to hear this matter at length.
Your Lordship, in the interim, Your Lordship, I would like to make a prayer. As at present, the entire keys is with in possession of the respondent number 1.
What keys?
Of the Darbar Hall and the other facilities which was in my possession at first instance, which I have complied in accordance with the last order.
You're removed now, you have no right to the keys anymore.
It's it's with the KHDC, Lordship.
Then?
My humble prayer is that there are some utilities and materials, Lordship.
What utilities?
Lying in the Darbar Hall,
what
like the chairs and some utensils which is required.
Yours?
Yes.
Your personal items?
No, not my personal items. It belongs to the Darbar Snong and of the this Senkantay, Your Lordship. Yeah. So they need now presently to utilize in the village.
You make an application, you write down articles, 5 chairs, 6 chairs or utensils, whatever, will order release to the Senkantay, whatever.
Okay, Lordship. I'll present before the respondent 1.
Not in the guise of release some things, you go and start tampering with the records. We can't allow
No, the records are in possession of the respondent number 1, Your Lordship.
Give me the keys, so I'll take out
Lordship,
the
that's
things
what,
I
Your
want.
Lordship,
What happened?
My humble prayer is that...
smart move. So we'll go and start...
No, Your Lordship, not that. My humble summary is that let somebody appointed by the KHDC to be present, Your Lordship.
What?
Just to take out the utensils and the chair.
Senkantay has a thing, let Senkantay go and get the things.
Okay, Lordship, then
We'll appoint a neutral party. You file your application.
Yes, Lordship.
Yes, sir. It's a matter of admission hearing.
For admission hearing today.
Yes, on hearing the parties, though this matter was, though it was recorded in the last order dated 7/8/2025, that endeavour shall be made to dispose of the matter today. So it appears that a question regarding the applicability of the custom to election of the headman's arisen. Stop accordingly. We'll list this matter when? After 2 weeks. After 2 weeks, parties are permitted also to file added materials if deemed necessary. Yes. Even this is not recorded. If this is the main thing you're relying on,
we will bring out record. In the meantime, we will bring out record.
Yes.
But the interim order mechanically.
Which interim order? Yes, interim order which shall continue till next day. But can you come prepared? What is your name?
I've known.
Yes. You record.
Item number 3.
My Lord, respondent number 1 and 2 have filed the objections, my Lord.
My Lord, I've just received the copy of the affidavit by the respondent number 3 this morning itself, my Lord. 5 minutes before the court sat, my Lord.
5 minutes?
Literally, my Lord.
Actually, we had filed yesterday.
It's all right, then when do you want it?
My Lord, if your Lordships would be kind enough, my Lord, take it in the second half, my Lord. I'll just assess the affidavit that's been served, my Lord.
We'll have it when? Without
Lord, I'm basically ready. The substance of the application is similar to the respondent 1 and 2. I'm able to address these issues
tomorrow. As the constitution as the respondent number number 3. Number 3 has just filed their affidavit. Yes.
Item number 4.
May it please your Lordship.
Lordship, in terms of the last order, Lordship, the respondents have
raised a question of maintainability. So you start. Yes. What is the matter about? No.
But their question maintainability. I have to start. Issue here is, my lords, is restricted to this. I had done a DPR for the fisheries department, my lords.
Oh yes, remember that aquarium and yes.
Now that in principle was approved by the Union of India with certain requirements to be done at their end, my lords, for the purposes of approving that project.
Yes, I remember. Yes. Why maintainability? Yes.
May it please your Lordship. Lordship, I would submit in the first hand that this is clearly a suit for recovery, or at the very least a suit for alteration of a contract. It's purely a civil suit, Lordship, in the guise of a writ petition. As your Lordship is aware, writ petition requires some violation of fundamental rights, failure to perform a public duty. None of this is present in this writ petition, Lordship. This is clearly a suit for recovery, essentially, disguised as a writ petition. And there is also a certain issue of variation of the contract. There was a restructuring of the DPR that was required from them. And that has to be done. And thereafter, payments will be made in due course. So that is my humble submission, Lordship, my limited submission on this point.
Which one have they impugned? Which letter have they impugned? Whereby it's been cancelled or?
No, Malas, there is no cancel.
There's no cancel.
I am simply saying, Malas, I have done my job. I have given you the DPR. It has been accepted. If it is not
agreement, then let's come to agreement.
Well, let's kindly have a look at page, Annexure 3, page...
It's not a statutory agreement, yes.
Well, it's page 26.
Yes.
It's inviting reference to so-and-so. I am to inform you the firm has been selected for consultation and preparation of DPR for redevelopment of Fishdale Farm on the condition that your firm furnish the following criteria. The consultants must have previous experience, well as we'll skip all that. The fee quoted rate by you shall be paid on sanction of the project amount from the Government of India in 3 installments, so-and-so, so-and-so, so-and-so. In this regard, your authorized person from your firm may be debited on a date which will be intimated for your signing the agreement. There is no formal agreement that was signed after that.
There's no agreement.
No, Malats. No, lots. But thereafter, Malats, the project was submitted, in principle accepted by the Union of India, with certain modifications to be made. I have been writing to them. If you want me to make the modifications, please tell me. I will do the needful. Whatever needs to be done, Malats, will be done. But at least my payment should be released. It's an admitted position, Malats, that the DPR has been given.
Oh, and your DPR, how can it be on agreement?
I'm sorry, Malats.
How is it possible that you didn't write any? It's a EOI is floated, correct?
Malats.
Then you responded to the expression.
Lordship. Accepted.
Accepted by this letter.
Malats.
That's all. 18 July 22.
Malats.
And Lordship, to that, pursuant to that, they had actually submitted a DPR. The Government of India had requested, on the basis, if I may refer your Lordship to paragraph 8 of their writ petition.
Yes.
If I may just read through this paragraph, there was a restructuring that was requested by the Government of India, and that has not been done yet.
Only one thing that's going through, whether they're out in the cold or there's still hope for them to, to be still engaged in a project for which they...
Lordship, all that's required is a restructuring, after which payment will be taken care of.
A DPR is prepared and given by us, Malats. There was a slight modification that is required. Now that request for modification from the Union of India has gone to the state.
Yes.
I have been writing to them, says that if you need a modification, please tell me, I'll do it. Correspondences are on record. Neither am I being favored with a response to that, nor is my payment being held. In spite of the entire DPR being submitted, its presentation being given before the Government of India, accepted by the Government of India, my money is stuck.
No, the thing is that, see, if you want to maintain a writ, there has to be an admitted
Well,
amount.
it would have to be an they're not denying it.
Certified bill and like admitted amount. For
Well, they're not denying it. If it comes on affidavit saying that we deny Mellons, they dispute that amount, then of course Mellons, my remedy will be then before a civil court. The Lordships are aware on this.
Lordship, if I may, this is just a question of redesign, after which the contract will take its own course.
We'll pass direction, we'll dispose of. Yes, heard Mr. K. Paul is assisted by so-and-so the petitioner, and also Mr. ESD for state respondents. What about Dr. Mozika? State respondents and Mr.
That's for the Union of India
for the pro forma stop. The grievance of the writ petitioner is with the non-payment of
admitted dues, Mellons, amounting to 265 Mellons.
Amounting to rupees 2.65 crores 50,000, which is stated to be on account of preparing a detailed project report for a project known as the Meghalaya Oceanarium. Stop. Next paragraph. Mr. ESD, Learned Counsel for the state, has however raised questions as to main temporary writ petition on the ground that the matter is purely in the realm of a private dispute and does not warrant any interference by this court in exercise of powers under Article 226 of the Constitution. It is further submitted that the writ petition is also premature in view of the fact that the state respondents are still awaiting further directions from the Union with regard to the change in the scope or design of the project. Therefore, prays that he therefore prays that the matter be closed at this stage itself. So Mr. K. Paul, the Senior Counsel, on the question which was submitted, that the petitioners, in reply to an expression of interest floated on.
I'm sorry.
When was the EI floated?
Well, it's the DI was floated on 29/11/2021.
On 29, the same
work order issued on 18/7/2022.
And a work order was issued on 18th July 2022. A work order for consultation / preparation of DPR for redevelopment of Fishdale Farm. Fishdale Farm Bragfish Complex was accepted by letter dated 18 July 2022, and on this acceptance, though no formal agreement was signed, the petitioners had commenced the work and, as required, had submitted the detailed project report. So, however, he submits for reasons unknown, except that there was an alteration to the scope of the work, the dues have not been cleared. So, next paragraph. This court, on hearing the parties and examining the materials in the court, this court has, on hearing submission, the counsel parties on examining the court, it is seen that the matter is purely in the realm of commercial law, and even though in absence of agreement, a remedy would lie before an alternate forum. Stop. Be that it may, in consideration of the facts as placed, it is also noted that the project is still not complete. It is noted that the same is still in the stage of, what stage is it in now? what can we call it?
Restructured DPR.
Submission of restructured DPR.
And it's also not a case of the petitioner being ousted from the project itself. So in this view, the matter, in consent views this court, no orders are necessary at this stage. Only that the state respondents are directed to complete the due process.
Act in terms of the letter dated 9 January 2023.
Due process.
Lordship, if I may, this is the state. We would request some time.
Yes, no, due process. Yes, due process. With whatever is required for completion of the with the due process with regard to the, what is this called? The
completion of the project.
Completion of the project. Yes. Stop.
Meghalaya Ocean Area, that's the name of the project.
No, we'll not try that also. Let's see as a dictate from the court to complete the project. Anyone necessary before that? On here submission
Lordship, if it would assist, if I may refer your Lordship to paragraph 8, there's actually a Pradhan Mantri Matsya Sampada Yojana, which is this is a new scheme instituted by the central government, which is why the DPR required restructuring and redesign. There's a paragraph 8 of the petition.
You should have written that. Where have you written that?
Well, may I just draw your Lordship's attention to page 54? That's the document that my learned friend is referring to.
54.
Mallet.
Yeah.
This is the Mallet's communication dated the 9th of January 2023, under which they are required to complete it.
Of an agreement. The remedy would like for alternate remedy. Stop. However, it is also noted that the project in question the event has been. However, we noted that there has been request from the Ministry of
Fisheries, Animal Husbandry and Dairying
that the state respondents submit a restructured proposal. In accordance with what's this Pradhan Mantri
CSS Pradhan Mantri Matsya Sampada Yojana
PMSSP MMSY so and so the matter has been held up. Stop. Accordingly, no orders necessary, only that the state respondent directed to proceed accordingly as per the directions contained in the letter dated 9 January 2023 issued by the said ministry. Stop. The petitioner is at liberty to resort to other remedies. Yes.
Well, it's
allowed by law. Yes.
Well, that would actually
preclude you,
prejudice me to the extent. Two aspects, if I may point out. My lords have directed them to proceed in terms of that. No grievance with that.
Well, you're not ousted, you see. That's the thing.
Well, I'm on that. But my lords are indicating that there is an alternative remedy.
If you have any other grievances.
Well, then even in a subsequent proceeding, I would then be precluded from approaching this honorable court.
Who can preclude you approaching the court?
Precisely, Lordship.
My lords may kindly appreciate if my lords just bear with me for 5 minutes. My lords have noted in this order that it is in the realm of commercial law and my remedy lies elsewhere. Once that falls from my lords in these proceedings, I would be precluded from approaching this honorable court for all other proceedings.
At this stage, Mr.
My lords, if to that limited extent
that you have with the state government as all,
I'm sorry,
not a statutory contract also.
Well, it need not be.
See, even then, it's purely a private. It's the realm of private law.
Well, it is not within the realm of private law. If your lordships want me to satisfy your lordships on that, I'll do that.
Anyway,
My lords, what I'm only praying is, your lordships have not...
We'll score on last line.
No, my lords, my lords have not entered into the, my lords, merits of this matter. If only that is recorded, my lords, it is only for the purposes that my lords have not entered into the merits of the matter. That should suit my purposes.
Yes.
Item number 5.
Obliged.
May it please, Your Objection has been filed, my lord, today morning only.
This morning they've served me with the objection, my lord. So I'll just go through the objection.
Matter, Mr. Lombri.
No, my lord.
See, you do some.
I'll cite the rules, my lord. I'll cite the rules. I'll cite the law also.
Private right also.
Lord, I'll cite the rules and I'll cite the law also, my lord. And you have it next week, my lord. I've just been served with the objection. Lord, it's not a general election or state assembly election where there's a clear bar under Article 329.
You see,
Lord, these are under the rules.
You see that the thing is that who are you? In which way have the voters here before us?
No, my lord, I'm not challenging the outcome, my lord.
Then are you sure who are you going to vote for?
No, my lord.
Then?
My lord, kindly have it next week. I'll satisfy your lordships.
Court not inclined, Lombri.
My lord, I'll try my best, my lord. I'll try my best.
Lombri will make endeavor to satisfy.
Of course, he shall make endeavor. But I'm just telling you the court was not inclined.
My lord.
Yes, because it's a purely. See, it has to be very specific. Election
matters are very
connected to election.
Yes.
Yes, it can't be general.
My lord, because the provision of election petition under the rules, my lord, is only for corrupt practices, my lord. Now this does not fall under that, my lord. I'll satisfy.
You can't generalize it. You have to be a voter. Even if it's not corrupt, you have to be a voter. You come by writ also. To say that I was prevented, we were so and so. Nothing of that. It's just a general thing that so and so has happened. So you can't have that.
Item number 6.
It's undisputed, my lord. It's undisputed.
If you can satisfy.
Yes, I'll try, my lord. I'll try.
Yes.
Item number 6.
Item 6, I'll require more time to file my rejoinder, my lord. Mr. Goyal is appearing virtually mute.
Yes. I am for respondent number 1. I'll require some time to file my affidavit also.
I require some time to file my rejoinder, my lord.
Yes. How much time?
3 weeks.
2 weeks time. 2 weeks time granted to the petition to file rejoinder to affidavit file number 2 and for affidavit on behalf of number 1. You are for?
Respondent number 1.
No. Just after 2 weeks.
Deep.
Obliged.
7.
Number 1. Court hearing not.
Your Lordship, pleadings have completed. It can be fixed for hearing, Your Lordship.
Have you filed your rejoinder?
Yes, Your Lordship. It can be
Yes.
fixed for hearing, Your Lordship.
No urgency?
No, Your Lordship.
Yes. Party submit pleadings to complete this after 2 weeks for hearing. So and so and so.
8.
Obliged, Lordship.
8.
My lord, in this matter, the petitioner is supposed to file the rejoinder, my lord. But here in this matter, I pray for some more time, my lord.
Why?
My lord, the petitioner has filed an RTI, my lord, before the state, my lord, and also to this SMC, my lord, regarding of these issues only, which is required to be filed as a rejoinder, my lord. So kindly accommodate me for 3 weeks, my lord.
3 weeks?
Yes, my lord. Because by the time, my lord, she has been filing the RTI just last week, my lord. So she instructed me also, my lord, that...
The only thing that you remember a managing committee.
Managing committee and the state...
That was your only claim to being employed.
My lord, in that
Since you are
aspect...
doing a lot of effort and legally it matters, so we'll grant you 3 weeks time. Yes. 3 weeks for the time this final opportunity is granted to the petitioner to file rejoinder.
Correct, my lord.
Item number 9.
Highly obliged, my lord.
Lordship, in this matter, the state had prepared the affidavit, my lords, but there were some clerical errors. I have the affidavit with me right now. But my lords, there were some typographical errors. Kindly give me some more time.
Your Lordship, in this matter, I pray if it may be sent for mediation, Your Lordship, as the respondent number 5 is ready for settlement, Your Lordship. If the petitioner agrees, Your Lordship.
Yes, petition matter.
Yes, Your Lordship.
Yes, parties, the contesting parties, namely the petitioner respondent number 5, the matter be sent for mediation, as there is a possibility of the matter being settled out of court. And so accordingly, the matter refer to mediation committee.
Lordship.
Necessary action.
10.
Lordship, in this matter, we have taken a step to issue a notice. Lordship, in this order, as per the order 2907/2025, there is an order for to get the instructions from the government, the mode of election. Your Lordship, I have this mode of election, how it is prescribed.
Yes.
They have.
They file affidavit.
No. There is a specific instruction, mode of order.
Lordship, we've received documents, my lord. May we place it by way of an affidavit, Lordship?
So let's see what's the mode of election.
It's election oblique selection, my lord.
That's a mode prescribed.
No, this
Lordship,
I have
this is
another.
as per issued by the Office of the Deputy Commissioner, my lord.
Let's say we have another. This is the election mode of election.
Let's see what's the mode of election.
That is. This is how the election usually conduct, Your Lordship.
Which part is it?
This is this is how the election or the entire.
No, what's this?
This is the mode of election. How the VSC election has to be conducted. This is a prescribed rule, Your Lordship. This is issued by the video program officer, Cesala shall develop. This is the way.
Haripur, this one.
Yes, Haripur and
Haripur.
This is Haripur. Of course, this is Rajpur. But then, Your Lordship.
Only regard to Haripur.
But then
this is different block, Lordship.
Different block. But then the Lordship, this is how in all the different blocks this election has been held. Usually, they have given its every detail. This is the type copy, Your Lordship.
My lord.
Where is written that they would cast?
Yes, Lordship. I may edit, Your Lordship, that everything the number 1 to 10. Then
where does it say second ballot?
First,
Mr. P.T. Sangma.
Their Lordship, yes, that I don't write a page. The next page, it is there given the date of filing of nomination.
No. Where is that? They should be by second ballot.
Oh, second ballot, Lordship, it is there, Lordship.
Where is that?
Yes, sir. Give the election. That's number 9. Each candidate will allow one person as polling counting agent inside the hall. That means.
What about this? See, this is. It's not satisfactory. What are the kind of elections are permitted?
My lord, we have the CNRD department notification, my lord. I've just flagged the relevant provision, Lordship.
You submitted that the elections will help raising of hands, correct?
No, I submit that there was no election. Then there was only a selection.
On hand raising.
Not even hand raising, they just selected.
That is your submission. That
was a submission.
The Green petitions that there was no election for the current VEC,
yes,
but that the seems approved merely by selection or consensus by hand raising.
Yes, but hand raising. But I said there is no election was held. It's only selected.
Hand raising won't be an election.
No, Your Lordship.
Why?
Because there was only it's only a selection. There no job card holder was participate. Only some few members were there.
You mean to say that there was no verification of
no
job
verification
holders who entered the hall for hand raising?
Nothing. That was not done.
Where have we written that petition? How do you substantiate
Yes, I have specifically in my mention it petition, Lordship.
How?
It's very notification. The school VSC. It's notice. Para 9 that I have prescribed. That 10 also it is there in the Presidential Committee on Consensus according to
No. Where we said that the people who were in the hall and that time when they had the selection or election, they were not job card holders. Where have we written that?
Nowhere, my lord.
There was people come outside. We can understand if your grievance is that there was no be a selection or election of the VEC, correct?
Yes.
Now people who are not member of that village employment council, who are not job card holders, they came to the hall and disrupted the elections and raised their hands, and those votes were counted and you were kicked out. We can understand.
No. My contention was there was no election at all. There was no election at all. No election was conducted. No hand raising also. There was no nomination. I said I have in para 9 of the petition I have stated there was no nomination. There was no contestant.
There's no contestant.
No contestant at all.
Then how was election done?
That's why I said there was not at all election.
There was no election.
No election.
There was no meeting of any people.
No meeting of any people.
It's done
just select.
Secret.
Yes.
By who?
Secret.
By the video.
By the video.
He sat in his office and said
yes.
the election's been done.
That is what I. That is my.
How can substantiate that?
That's why that let them file the.
That's why.
Yes. Because they have.
Mr. Jokes aside, you have to. If you come before the court, you have to come with materials that allows the court to see that whether there's any genuine grievance.
Yes,
not some disgruntled person who just comes and files just for the sake of filing.
No.
Time.
That my particular details
not. After this file, it shows that there was a proper election. What happened?
No, my saying is that there was not at all no election at all, my lord. There is no election at all.
You file affidavit then.
No election at all.
Yes. Today, Mr. P.T. Sama has changed his stand by submitting on the production instructions by the government advocate that there was no elections at all, and that the procedure as prescribed was not followed. Stop. A procedure was not followed in as much as the election was done at the level, the selection at the level of BDO himself. I am recording those allegations made. That's done at the selection was done by the respondent before BDO himself. Just after 2 weeks for affidavit is the respondents.
Much my lordship.
You bring all the details. If
lordship.
This all will cost.
My
you
lord.
can't have these kind of litigation.
Lordship.
Too much from this VEC matters.
11.
Any allegation you make. After verification, job cards also still aggrieve. Want to do your own verification.
No, let's say it.
Item 11.
What's the last lordship?
May it please your lordship. Lordship, we've just received instructions, my lord. May we be allowed to have some time to place our affidavit?
Yes, Ms. Hassan.
My lord, yes, my lord. Since election was held on 18/7, and my two grievances, my lord. The one, my lord, the 14 job cards were cancelled, my lord, as I submitted earlier, my lord, in the midnight, my lord, on 17 midnight. And second, I was not allowed to, my agent was not allowed to participate during the election process, my lord. I was thrown out from the election proceeding, my lord.
Even if all those people who are not allowed to vote, Ozim not there, had voted for you, you won one elections also.
That is not the question, my lord. Because of the entire election proceeding has been disturbed, my lord.
That come say I'm going to place funds around 2 weeks time to file.
And reason given by the same kitchen, the petition, the respondent.
Much of my lordship.
Yes, ma'am.
There have to be different system for elections.
My lord, my lord.
Second call, supplementary list item number 2.
Every election, everything is challenged.
My lord has to set some rules, my lord, guidelines, my lord. Hello, please.
Yes.
Lord, the affidavit. Lordship, have the affidavit, additional affidavit filed today morning, Lordship.
Where's the petition he filed before the
Lordship, page 6 is the type copy of the notice, Lordship.
Yes, and the affidavit has been filed today by the respondent number. Respondent
4 and 5.
4 and 5.
Bring on record the fact that the petitioner has also filed a petition before the National Commission
for Scheduled Tribes.
For Scheduled Castes.
Scheduled
Scheduled
Castes.
Castes. It is submitted by Mr. K. Paul and the Senior Counsel that the petitioner should choose his remedy as to whether he will pursue the same before this court or before the National Commission for Scheduled Castes. What is your submission?
Well, it's just one thought. For Lordships to direct the Commission not to proceed may not be proper. We may write a letter. I'll endorse it as well. For them not to proceed with this matter since I've approached this Honourable Court.
That submission can be recorded, Malad.
Yes. Mr. S.N. Leonard, counsel petitioner, does not dispute the fact that a recommendation has been filed before the National Commission for Scheduled Castes, for which notices have also been issued to respondents number 4 and 5. However, he submits that he prays him allowed to seek remedy before this court, and that he will take appropriate steps with regard to the matter pending Financial Commission, Scheduled Castes, to keep the same in abeyance pending the disposal of the writ petition. Accordingly, the same is noted. Ordered accordingly.
Highly pledged.
Item number 1, daily list.
Where's MS Kolni?
So, Your Lordship, we have withdrawn this case because now it's become infructuous. The petitioner now he has jumped ship.
How much cost should we inflict? For the benefit of all the lawyers here, really High Court Bar Association.
Lordship, I have already filed a withdrawal petition, my lord.
Yes.
It is with the registry, my lord.
How much cost you prepared to pay?
My lord.
Cost. For taking the time of the court.
My lord.
For the benefit of High Court Bar Association.
Let this be the first occasion, my lord.
5 lakhs.
No, my lord.
10 lakhs.
I will not be paid that much also, Lordship. So that will be too much.
But you will not be paying for pocket.
Yes, with the application withdrawal.
My lord, it's with the registry.
I think that'll be better come on record because
yes,
we'll pass orders then.
Yes, yes, ma'am.
Grateful.
Hearing. Supplementary list item number 3.
The last hurdle, my lord, which I have to overcome is that whether he has any connection with the courts or not, my lord. The appointment letter, which my lord was interested to see, my lord.
Yes.
The appointment letter, which was given to me, my lord, on 1st June 2015. If my lord may kindly see, subject.
1 second. As it is, the print is very blurred, my lord.
Yes.
1 second. It's called BSF Engineering Setup.
Yes, my lord. Engineering setup.
Correct, Dr. Modika.
And second thing which I was insisting on the well,
the reference is also read Mr. D.
Offer of appointment for the post of Head Constable Technical Group C post in BSF Engineering Setup Civil and NDRF BN 2014-2015, my lord. So I am in the engineering setup, my lord. That is not disputed, my lord. This appointment speaks volume, my lord. Now, my lord, may kindly see page 4, my lord, of these documents. This is a clarification which has been given by the DG. My lord, may kindly see priority from headquarter DG BSF, my lord. Now, what clarification they are giving, my lord? Promotion of Head Constable Fitter, my lord. Pioneer and Fitters. It's your documents only, I mean. It's your DG has written this letter.
Next higher rank.
Yes, my lord. The next post of higher rank is, my lord, SI work, my lord. My lord, may kindly see page 4.
Of what?
Of the documents that I have furnished.
Give me a problem.
I will give you. We'll share it. We'll share it.
How will I respond just like that?
And this is their file, my lord, from I've got from their office only, my lord, these documents. Probably they should have in their file, my lord, these documents.
I'm not with the entire file of that.
You brought entire file?
I don't have entire file.
Last time, my lord, it was my lord has expressed.
Give me a copy. What is placing for the
only one hurdle has to pass. He's crossed the first hurdle that 3 years can be compressed to 2 years.
Yes, my lord.
Very good. Now he wants to show that the post he's serving now is connected to the course he's seeking to pursue.
Yes, my lord. Yes, my lord.
So he's shown now. I don't understand this one also. Needs some
citing some
interpretation.
document. Give me a copy.
These they are documents, my lord.
But as my document, if he's also appearing for district, he doesn't carry the entire file with him.
My lord, may kindly see this. I will share with him, my lord. If they are disputing so much, my lord, this is the comment which was asked from my superior, my lord, by the BSF authority. This was asked from.
What is this one? From promotion of HC, pioneer and fitter.
Yes.
The next higher rank, reference, frontier head H, so Punjab, so which applications have been following.
This was asked in connection with Punjab, my lord.
Yes. Next. Rank Manoj Sharma. He's Manoj Sharma.
No, he's not Manoj Sharma. It is connection with fitter, my lord. I am referring. My lord, may kindly read the last para, my lord. As per BSF Engineering Civil Combat Group B post RRS 2013 for the post of SI work, BSF head constable, carpenter, so and so, operator and fitter, my lord. I am also included, my lord. And my next promotion is SI work, my lord. No, second thing, my lord. I will just place this, my lord.
It's not you, this one.
No, this was not me, my lord, but clarification was given by the DG. And now, my lord, they cannot go beyond the DG's authority, my lord. My lord, may kindly see this. This is a clarification was seek, my lord, by the establishment branch, my lord. Assistant Commandant, Ministry, Establishment Branch. These are the questions which just put, my lord, to my superior, under whom I am working, my lord. The question was whether the post.
Dr. Mosika's answer, see this one.
This answer, they have never brought it.
He used to give me a copy, my lord.
My lord, let him
shooting like that, my lord.
You can't keep it in your pocket only.
No, I just got it, my lord. I just got it, my lord. 2 copies. I can show it to him. He can produce.
Let him file an affidavit, my lord. I can answer like.
My lord, I will miss my course, my lord. Again,
affidavit. See, this one is your inter-office branch. See.
If required, I will give him, my lord, right now.
You have to just verify, Dr. Mosika, whether this is DC works is competent authority issue certificate.
This is not the certificate. This was clarification which was sought from my superior, my lord, whether this.
See, hence diploma in civil engineering is close connection to sphere of duties.
Yes, my lord.
Take down.
My lord is referring to this 12th March 25, my lord.
Yes.
Lord, say something different, my lord.
Yeah, no, same.
Why should I have a view?
My document is something different.
12th March only.
Last line.
You see this?
Last sentence. Let him go, Dr. Mosika. Oh, he's already finished the diploma, correct?
No, my lord.
Yes, take down. Today, pursuant to the order dated. Order dated 11/8/2025. SDA has produced some materials to substantiate the fact that a diploma in civil engineering is in close connection with the sphere of duties of a fitter. Dr. Mosika, however, is not aware about the said communication. He prays aloud 3 days time to obtain final instruction. Listen on Monday.
My lord, a week, my lord, I will miss my course again, my lord.
Monday,
my lord. My lord, it's okay, my lord. Monday.
After 1 week, then I'll go to next Wednesday.
My lord. Monday, my lord. Come up.
Give him the copies.
I've given him, my lord. I've given him.
Item number 4.
तो मैंने तुका मेगा टेक्निकल सिस्टम नहीं अच्छा देखती
Distance कम ना
टाइप तंग तुका टाक kan badan le ufine ko rebo what amount is there?
Okay, sure. Chip,
you made
this is in the affidavit to bring on record dated
filed by you.
Yes, filed by me. Chip. This is dated 13 May 2025. 13/5. the calculation.
2,82,000.
Yes.
Total 3,49,000.
Total is 3,49,000. Yes, Lordship. Para 11.
The state has to pay this, that means? Who has to pay it?
According to the state, the union has to pay that. That's what, as per the office circular of
Union has to pay
1997.
it. You got instructions on this, Dr. Morzika? This affidavit was filed since 13th of May.
Last date, learned senior already considered that they were okay with the amount.
Is that
The only issue will come. The petitioner was in service of our state government, my lord. He went on deputation and finally absorbed in negligence, my lord. For the period he served in state, his retirement accruals, whatever were there, my lord, were required by the state government to transfer to negligence, my lord.
You're not transferred as yet.
Which has not been done. So, my lord, what I would pray, my lord, the matter can be disposed of. We will pay, my lord, but the state will transfer that money. We'll sit with negligence, my lord, and they'll work out what is the liability.
This is your lordship. Lordship, I have a serious objection to the bank by the.
My state cannot wash off hand just like that, my lord.
Lordship,
But I'm only saying,
affidavit filed by
my lord, what I'm saying, my lord, let the state, the competent.
We have no liability, your lordship. The state has no financial liability, your lordship. Lordship, can you have the affidavit filed by the writ petitioner, your lordship?
Yes.
Lordship, before your lordship.
But I'm not saying to your lordship to adjudicate who is liable. Let them sit, my lord. Negligence and state can sit, can sit, and whatever they can work it out, whatever is as per the rules.
Lordship, can we have page 14 of the writ petition, your lordship?
Why if we come to the affidavit filed by the last affidavit filed by the writ petitioner?
That additional affidavit, I would like to take your lordship to page 14 of the writ petition.
Page?
Page 14, your lordship. That is annex of 4. That is the order of appointment issued by the NECREM, your lordship.
Yes.
Lordship, may I read it, your lordship?
Yes.
The director, Northeastern Indira Gandhi Regional Institute of Health and Medical Sciences, Shillong, is pleased to order the permanent absorption of Shri Q.R. Marak Pion in the service of the institute. Again, the post of Pion with effect from 1/1/1999. His services, Lordship, can you see? His services in Government of Meghalaya is counted for the purpose of regulation of the relevant period towards pension. So, Your Lordship, the appointment is very clear, Your Lordship. Then, Lordship, can you have the affidavit, additional affidavit filed by the writ petitioner, Your Lordship? Lordship, the updated fact is that the writ petitioner has been released from the state service on 24/10/1989, Your Lordship. And the last extension, Your Lordship, can you come to page 17 of that?
Which affidavit?
Lordship, the affidavit.
Last affidavit?
Lordship, that is the affidavit by the writ petitioner, Your Lordship.
Which affidavit? When?
They are to bring on record, Your Lordship. That has been filed on. We received on 11 December 2024, Your Lordship. That has been filed on.
There are two affidavits filed by him.
11 December.
10
Yes.
December, Your Lordship. 10 December. Lordship, can you have page 17? Lordship, the type of
Yes, okay, just read. You can read this one also. Annexure 8.
Lordship, yes, Annexure 8. In continuation to this department letter number so I am directed to convey the sanction of the Governor of Meghalaya to the extension of the term of the petition of Shri Q.R. Marak, Peon of Meghalaya Civil Secretariat, to the Northeastern Indira Gandhi Regional Institute of Health and Medical, Shillong, for a further period of 1 year with effect from 1/11/98 to 31/10/99 for the same term and condition as laid down in this department original sanctioning letter so and so, but without deputation allowances. It is also requested that the formalities relating to permanent absence should be finalized within the year of extension. So, Lordship, from 1989 till 1989, Lordship, that
successive orders have been passed.
That has been extended by the state government from time to time on a yearly basis, Your Lordship.
Okay, Mr. Marpan, after the settlement amount of 3 lakh something,
yes,
what amounts are due?
There's no amount due. This is the only amount due.
That's it.
Yes. One thing would be clear is who will be liable is one letter of 7 February 1986. This was submitted by the Union Government of India, Ministry of Personal, and I think it's there in the record, not with an affidavit, was just placed before the court. This is 7 February 1986. It should be there, 7 February 1986. There's a circular.
February
1986.
Yes.
I may read, Your Lordship.
Counting of service.
Yes, counting of service for purpose of pension of employees of central government and central autonomous bodies seeking absorption in autonomous bodies under the state government and vice versa. So the first paragraph itself, Your Lordship, towards the end of that paragraph, the last 5 lines.
Yes, similarly,
certain central government servants and employees of the central autonomous body, statutory bodies might have joint autonomous bodies. Statutory bodies, excluding public undertakings of the state government, may be desirous of getting the benefits of counting service under so-and-so bodies towards pension in the government where they are presently working. So it will be counted where they are presently working.
Similarly, certain. No, this is not clear. This is when they go from to the state.
So vice versa also.
Vice versa.
Okay, no, it's not top. See, the same procedure apply in the case of employees of autonomous bodies who are permanently absorbed in central government. Certain employees of state government and state autonomous bodies who join the central autonomous statutory bodies have also presented that their service as state government, state autonomous body may be allowed to be counted towards pension under central autonomous body
where they are presently
working. Yes, then Dr. Mozikar settles it.
It's settled.
And this earlier order, another order also by the Government of Meghalaya.
But this is only for counting of service. Counting of service, there is no dispute about counting of service, my lord. But my lord, during the period when he served in state government, my lord, every from the salary of every.
But for release is 89, were the successive orders.
24, your lord, 24/10/1989, your lordship.
Yes.
And has been.
They continuously they pass orders.
Lordship. And then the order of extension of
because the only period we were concerned about was that he went on deputation on 1989. What happened in the intervening period from 89 to 1/11/99 when he was permanently absorbed? That's the only thing. That was the lacuna.
Well, not only that, my lord, even from 84 when he joined state government, my lord, and he was in service of state government full-fledged well till 89. Every month from his salary, certain amounts are deducted, my lord. Even if we leave.
So you want a 5-year amount also?
Well, that amount the state has to transfer to
yes,
us.
Mr. Shulai, he has a point. The thing is that he joined service 84. So amounts deducted from 84 to 89, 5 years. Where is the amount lying?
Lordship, he has that
No, fine. We understand. 89 to 99, no issue. Now only the other issue is that if he joined service 84, now 5-year deductions are made. Now, if he's going to get settlement, that means
that at least, my lord.
That amount has to come to the half the amount has to come to the petitioner. Correct.
So that's what I'm submitting, my lord. That will be direction let state government and Negrims settle the matter among themselves.
Half the amount, half if GPF's half the amount should go to the petitioner. Correct.
Lordship, we have no
full amount should go to petitioner.
Lordship, we filed the affidavit. Lordship, kindly have a look at paragraph 6 of the.
The full amount should go to petitioner. If they are paying him, then we adjust it
against amount. As far as Negrims, we have paid him full amount, my lord. Only some component was left. We will pay.
Now 84 to 89. If they deducted and that amount lying with them, it should go to you now to adjust against amount paid to him.
We have no pending.
We will say the no pending. It doesn't make any sense, my lord.
Then we can't dispose this matter today, Mr. Dr. Mojikar. The poor fellow now is how old is his age now?
Age.
Madam, let there be clear direction. We will pay, my lord. Let there be. I have no problem with that, my lord. But state will calculate the amount for that period at least and transfer that money to negligence, my lord.
Yes, Mr. Shulai, agreeable to that?
Lordship, my submission is that the state has no liability whatsoever.
That's the instructions also.
Lordship, yes. We filed the affidavit, Lordship. Then we have
How can that be? They can bring a piece.
Because the affidavit doesn't mean they'll go against the law.
They can bring a piece of paper, my lord, that 5 years there was no deduction, my lord. Or, in the alternative, they've transferred their money to negligence. At least something has to be there from their part.
It comes to him, he has to refund that amount.
It is very clear, my lord, the state has not paid any retirement benefit to him, my lord.
Yes.
I would direct them to state to file an affidavit within 7 weeks. How much was the money deducted, my lord? From 84 to 89 at least.
Yes, take down. Next paragraph. This matter, which concerns the where's the petition? This matter, which concerns the the petitioner is before this court with a prayer for release of his retirement stroke pensionary benefits to which is entitled, but however have not been released, though he has retired as far back as on 39/2021. Stop. The brief facts are that the petitioner was appointed as a peon by respondent number 3 bracket state respondent, and thereafter on 1/11/1989 was deputed to Negrims bracket Northeastern India Regional Gandhi or Northeastern Indira Gandhi Regional Institute of Health and Medical Sciences with effect for a period of 1 year, which continued for 10 years, whereafter he was permanently absorbed with effect from 1/11/1999. It appears that the non-finalization and release of the terminable benefits due to the petitioner was on account of the lack of clarity as to who would be the appropriate authority to release the same for the period to release the same, inasmuch as the petitioner was on deputation for a period of 10 years. Stop. Stop. Next part. In the course of the proceedings, with regard to the aspect of the period of deputation, that is from what is it here? From 1/11/1989 to 1/11/1999. The same has been resolved. Where are those series of letters where your affidavit
Affidavit
where
is
you
that,
renewed time to time?
Yes.
And resolved?
This is in the affidavit of last year.
69. So wait. Were resolved in as much as the letters, in such as orders of extension of deputation by the state of Meghalaya have been produced before this court, which reflects that for all practical purposes, the writ petitioner was no longer in the services of the state government. So, thereafter, as this matter stood resolved, the matter resolved in the in connection with the calculation of the arrears of retirement and gratuity due to the petitioner, an affidavit has been filed by the petitioner computing the said amount with interest in terms of Rule 45 bracket 1 bracket small a and Rule 65 of the Central Civil Services bracket pension rules 2021. The amount, computed amount as stated in the affidavit dated 13 May 2025 is rupees 3,49,890. This amount, the amount payable as per the amount payable, this amount therefore necessarily will be payable by the negrims, as the writ petitioner has superannuated from the central government itself. Stop. Next paragraph. Dr. N. Mozikala, DSGI, appearing for respondents number. Yes.
1, 4 and 5.
1, 4 and 5 has submitted that for this period for which the Lucona existed earlier, that is from 1989 to 1999, in view of the circumstances and facts as placed, the said respondents are agreeable to pay the amount as computed. Stop. However, the Learned Senior Counsel has drawn attention of this court to the fact that if the writ petitioner The writ petitioner, no, I don't know that the writ petitioner was in service since the year 1984 to 89 under state respondents, for which certain deductions must have been made. He further submits that as the respondents 1, 4 and 5 are settling the final dues of the petitioner, these amounts, which therefore will surely be lying with the state respondents, be directed to be transmitted to the respondent 1, 4 and 5. Stop. Mr. N.D. Shulai, next one, Mr. N.D. Shulai, learned EAG so-and-so, however, has submitted that. What is submission?
Has no liability.
As per
If Lordship kindly have a look at page 7 of that additional affidavit, Your Lordship.
The last affidavit?
Lordship, yes.
Then no, the amount still remains. It's beyond. It's beyond. See, Mr. Shura, it's beyond the scope of this case. We just give direction because if this due is due.
Lordship, kindly have a look at page 7, Your Lordship. That is the affidavit to bring on record the area, Your Lordship. Kindly see, Your Lordship, the petitioner's name, date of birth, Your Lordship, 16/9/1961. Kindly see, date of joining state government may be counted as entry to central government. Kindly see, Your Lordship.
So you're depriving him of that amount also?
So for that, Your Lordship, this is the document of the NECRIM only, Your Lordship. So they'll have to pay, Your Lordship.
This is not a this is a comparative charge that I made.
This is a chart made by the petitioner.
Comparative charge just to compare the amount.
Since the 1984 under the state respondents, for which certain deductions has been made.
Must surely have been made. Yes.
He further submits that after the respondents 1, 4 and 5 are settling the
Final dues.
Final dues of the petitioner. These amounts will
surely these amounts are to be adjusted and made over to the respondents 1, 4 and 5.
The state respondents be directed to be transmitted to the respondents.
And that the state respondents be directed to transmit this amount. Yes. Yes. Next para Mr. N.D. Shulai, however, submits that as per his instructions, there are no dues lying with the state government. However, as the government, and as such, the final settlement to be made by 1, 4 and 5 should close the entire matter. Stop. Mr. S. Marpan has no further submissions to make, and as Mr. Marpan submits that on receipt of final settlement, the petitioner, on the settlement, the petitioner's grievances will be addressed. And have no further submissions.
Just one thing, actually, the calculation is still May 2025 because the interest has been added as per Rule 65.
We only submit that as
already in August.
As the computation was made as far back in May 2005, the correct amount may be calculated and the pension of the petitioner be released accordingly.
As on the date of?
Yes, as on the date of released accordingly. Stop. This court on consideration of the facts of the case and also on the added submissions made by Dr. Mbuzika, deems it necessary, feels that it is not necessary to prolong the matter any further, as it is the writ petitioner who is suffering due to the non-release of the due payments. Accordingly, this writ petition is closed by directing the respondent 1, 4 and 5 to release the payments of the writ petitioner as due. And with regard to the question raised by Dr. N. Mbuzika, it is left to the state respondents and the NEGRIMs to resolve the matter at that level.
My Lord, the state will never do that, my Lord. Let there be direction, so state to calculate the amount and transfer it to defense file.
If the in this regard, It is expected the state shall calculate the amount, if any, and the same to be made over to the respondent 1, 4, and 5
within
a
time
period
frame, my lord. Within
of 5 months from to date. Yes, with the above directions, the matter of transclosed disposal. I'll not refer to notifications because as reverse on, it'll just complicate matters.
Yes.
Yes.
Oblige, Your Lordship.
Yes.
On the last occasion, I had placed one judgment which was passed by the Honorable Supreme Court. Mr. Debnat.
Court?
Your Lordship.
Which judgment?
This is 1022 SSC Online SC 1291.
You've given a copy last time?
Copy I didn't get in my...
You didn't get in your computer?
Yes.
What happened?
Your copy has been supplied. You're supposed to
Yes,
take
sir.
instructions.
See, Mr. Headman is a very wily customer. You don't know that.
Sir.
It's not as simple as he looks.
So you will say even...
Give him a copy of the judgment. His other I could not find it, he said.
Lordship, I have supplied him on the last hearing day.
He give the number.
Lordship, this judgment pertains to when the IO and the RO are of
Give
the
it to
same.
him, your copy. You will give to him.
I don't have extra copy right now. I have already supplied a copy, Lordship, on the last date. Supposed to come with instructions, Lordship.
Exactly. So he didn't. He doesn't have this judgment. How will he come instruction in the judgment?
You should have asked me in the morning, Lordship. Right now, I don't have an extra copy.
On the very particular side,
You can take my copy.
See, you can't have this kind of argument for this court that I
you
don't have a copy. I don't have a copy.
You can take my copy.
Yes. It'll already be reported now, I think. Or it's not reported.
It's reported, Lordship.
This is SC Online. This is reported in Supreme Court cases.
This is from SSC Online, Lordship. It's reported.
Understood. Whether it's come out in Supreme Court cases in the journal. So you can give
I'll
them.
have to verify that, Lordship.
So you will see in this matters, this judgment.
See, there's only one point, whether you can look at the entire years or the submission of the petitioner, I think, is only for those years for which he has represented. Only that should be taken into account. That's all. Not into his earlier service of 6 and 7 or whatever. Right?
They are taken from 1002.
Okay,
Earlier
1002.
records.
Give him 2 days. You have a copy. A copy of the judgment read upon by the petitioner has since been supplied to Mr. R. Debnat, who seeks 2 days' time to peruse the same. This is the matter next week, Monday.
Lordship.
See, Mr. Debnat is a very smart lawyer.
Your Lordship, this judgment may not be applicable because
that's what. Come on Monday. Don't.
16.
Yes.
Monday, Lordship. Oblige. Give back that copy.
Yes.
Please, Your Lordship, this matter relating to land acquisition, we've already did recourse to Section 64 of the Land Acquisition Act.
I've taken instructions, but the department has received this letter, so we'll dispose it in accordance with law.
Yes.
Well, that limitations that can be taken some consideration.
That Lordship's pleased to make any observation. The fact does remain, if there is any delay, we'll deal with it. He'll have to file an application for condonation explaining the delay.
Yes, of course. Mr. S. Marpan, yes?
I do have an objection regarding Section 64, my lord.
That'll be, you can put it before the collector.
My lord, if I may be allowed to place Section 63 of the same act.
It's RCLL, what's it called?
Right to fair compensation and transparency.
No, there was the abbreviation.
RFCTLA
RFC.
RFCTLARRA. It's a word in itself, yes.
My lord, if Mahalan friend refer to Section 64, I also would like to raise an objection on the Section 63, my lord.
Yes.
I may be allowed to read.
Yes.
No civil court other than High Court under the Article 226 and or Article 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which the collector or the authority is empowered by or under this Act, and no injunction shall be granted by any court in respect of any such manner. Where my learned friend have approached this Honorable High Court, and then Section 64 is totally barred by Section 63.
No. That is not correct.
No, that's not correct.
Authority is whom? Now under this Act, civil court is barred because a special statute that provides for a special court, reference court, to settle disputes. In the old Act, you had a special judicial officers call. So if the disputes, you go to the deputy commissioner under Section 18, he refers the dispute to the collector. Sorry, he'll refer the dispute to the judicial officer. He has to also arrive, on merits under objections raised by contesting parties, whether the matter is fit for reference. Under Section 30. Now this new Act has provided for Section 64. Now you read this one. Any person who has not accepted the award, see, we refer for so deduction measurement of land, who is payable to amount compensation. Then it comes for now the collector can reject the application also and not refer it to the special court. So you can raise objections there if you have any objections, because what is before this court is with regard to any violation of fundamental rights with regard to non-observance of the procedure established by law, suppose in the acquisition of your land. Then at that event, civil court jurisdiction is barred, and so under 226, this court will look and say yes, whether your rights fundamentally have been violated, but theoretically have been violated. And if it's any other disputes as to ownership, as to title, as to the amount received or amount of compensation which has been awarded or the amount has been assessed, that will go before the under the Act, before the authority.
Now, if it's that case, let me take instruction.
Instructions from whom? On law. You are the lawyer. Then it's not that the matter is closed.
Yes, sir.
It's just that you're playing a different league, that's all.
Yes, sir.
No, in 64 they'll also be given notice.
It's like that.
64 even they'll be given notice.
They'll surely be given notice because they are the
there is a proceedable notice.
Party in the suit. They are party in the suit, so definitely be.
Yes.
Yes.
Mr. S. Marpan submits today that the matter may be closed as the petitions preferred and the application under Section 64 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act of 2013. Stop. Mr. S. Sen Leonard Counsel for the response number
1 to 3.
1 to 3. I have no objection and submits and also concurs, and also no objection to the matter being closed, as the same will be dealt with by the authority under Section 64. Mr. Kharshieng, however, has raised certain objections as to
It's barred by jurisdiction is totally barred.
As to the maintainability of the petition application before Section 64. Stop. Learned Counsel refer to Section 63 of the Act and submits that jurisdiction civil courts is barred, and as such, once they have come before this court, they are stopped from approaching any other forum. On hearing the Learned Counsel of the parties, it is noted that the so-and-so Act is a special act which provides for, which I've read objective reasons for you also, which has been enacted for the purposes of matters related to acquisition of land. Oh, a very long statement of reasons. Yes. Yes. And as such, any matter or dispute treated there too, apart from where fundamental rights of citizens had to be violated will surely lie before the authority prescribed under the Act itself. The objection of Mr. Arka's hearing is therefore not tenable. Accordingly, the petition stands closed and disposed of. However, with the direction that the authority shall give due consideration on the matter of condemnation as the matters will proceed before this court. Yes, it is needless to add, proper notice shall be served upon the respondents when the matter is taken up before the said authority. Yes, matter only stands closed and disposed.
17.
This matter, this also pertains to promotion, ACR matter.
Same judgment?
No, Lordship. The other matter, this is the second round of litigation. In the other matter, this is the first round. Lordship is inclined to pass in similar lines, but to communicate the ACR, that matter has been taken up. One of the matters, Lordship, which your Lordship had passed an order, that is under appeal, Lordship. So I'm waiting.
Which one?
There's one matter, Lordship. No. This is another matter, Lordship.
You want to do the matter today?
No, Lordship. After 3 weeks.
They say that.
After 3 weeks.
Yes, Mr. Emmanuel praised that matter be. After 3 weeks to await outcome of
Division bench matter.
Division bench, matter of division bench, yes.
Hello.
18.
Lordship, as for the last order, they are supposed to produce the memorandum, draft office memorandum number that's 60991 dated 26.
Since it's just draft rules and it was not implemented, we haven't been able to litigate it so the year 1999. If my lord would note, if I may refresh my lord's memory, this is a case where he was appointed as a peon and then he was promoted as a sectional officer under draft rules, which was later on found to be incorrect since the draft rules have not been implemented. So, my lord, therefore, now he is already retired. What if my lord may have page 13, which is the office memorandum, he may reply, madam, may I appear?
Who's your assisting counsel here? Nobody. Are you in Kerala or in Delhi? Okay. Yes. Page 13.
Page 13, madam.
30 or 13?
13, madam.
Okay.
It's an office memorandum dated 26th July 1999.
Yes.
With reference to the subject matter above, I am directed to, so the subject matter is Meghalaya Ministerial District Establishment Service Rules.
Dash.
So it means I am directed to say the government is contemplating to bring out the service rules for ministerial staff in the districts and subdivisions in the state for offices other than that of DC, etc. For which service rules have already been filed, and for the purpose, this department have prepared the draft service rules which is enclosed here. Now this enclosure we don't have, madam. It is very clear from this that these are only draft service rules, and it's an admitted position that these never got implemented. That's not in this matter. Whether these draft rules were wrongly implemented, that's the issue. That these draft service rules, under these draft service rules, the promotion happened, which is at page 16, madam. It refers to this office memorandum. In pursuance of the recommendation of the Departmental Promotion Committee held on so and so, and in compliance to Government Office Memorandum dated so and so, the following incumbents are same office memorandum.
Now, one second, I've forgotten about the matter altogether. Were you regularized at all as a peon?
Yes, I happened to regularize, Lordship. Then after that only I was promoted, Lordship.
Where's that? Let's see your petition. On his written request. Okay, where's that? And if you're not entitled as section assistant, if your promotion was wrong per the draft rules, then there'll be nothing. It'll just be an aberration.
And at page 18, if my affidavit at page 18 or 18, the resolution we have come up with is, last paragraph, may be noted that the government reveals its ability to agree with the proposal for promotion of PN to the post of section assistant in respect of so and so, as there is no provision for promotion to the said post. However, the period already served may be treated as officiating basis and reverted back to the original post of PN. Now, we are willing to consider him for regularization, but cannot give him pension for SA.
No, has he been regularized or not in his original post as peon? Has he been regularized? That's the question the court's asking. Where is your order of regularization?
Madam, we are considering that as showing where.
He's not been regularized as yet.
Because, madam, he's as is showing. Whereas, if madam, you come to page 23, so his pension papers, etc., have been prepared, but he's basically not signing them because he wants to be considered.
No, has been regularized in service.
It's been listed after a long time. I really argued the matter previously. I'll just go back and see.
Only regretting the to promote is fine. Now, where a person so and so attached so reverted back post a section from so and so the 2025 is fine. Now, where is his regularization of service? Okay. He's not regularized, even if he was given a wrong promotion, he can't be promoted.
So selection committee, because I that page page 10, because that is a complete selection committee lordship.
No, where is your regularization order?
Selection committee, Lordship, though, that regularized the letter is not there, but as for the instruction, he has been regularized in the post of peon, the Lordship.
How is pension not regularized? That orders to come first?
I think last time I produced an order to that effect, if I am not mistaken.
We can't just be floating around like this. I don't understand it.
No, this is only with regard to pension.
No, but have you been regularized? Because we have to give that finding. There is put a peon only that his promotion was on the basis of draft service rules don't exist, and that's why the government cannot exceed. He doesn't have any enforceable right. That's the only thing. And so his pension be computed as per his peon. That's all. That's what. At least we have to have a tangible document. When is it regularized?
Lordship, I'll give sometime. I will get instruction, because that actually he did not give me the regularized letter. He only told me that he has been regularized, but he did not give the copy. And let me get a clear instruction so I can assist the court in a better way. I will prepare on that when he was.
No, to prepare, just produce a document. Yes, MSSR, and you also just find out when he regularized. Yes, this is a matter of 2 weeks. Enable the concerned parties to produce the letter of regularization or regularization of service of the petitioner in the post of peon. Yes.
21.
Yes.
Most well, Lordship.
Complete. Yes, Mr. I'll pass it to you.
Well, this matter pertains to pension. But the core issues, my lord, regarding entitlement of ACPS, because the petitioner retired in 2024 and was seeking to recover, my lord. Now, my lord, there are a batch of matters which are coming up on Monday.
When?
On Monday, my lord. The core issue, my lord, regarding entitlement of ACPS, my lord. So, my lord, there's a latest OM.
Bearing on this.
Yes, my lord. Latest OM was issued by the government on 9th of July. Now, in those matters, the government has sought to bring it on record, my lord. So this matter can be tagged along, my lord. We'll.
Yes.
You're aware of that?
No, that 9th July I am not aware of. Lord. Try to get. This one. Only this one. Only this
No,
one.
there are many more.
Many more. Okay.
Yes. Mr. Philman Noburi, learned counsel for the petitioner, submitted as similar matters are due to be heard finally before by this court shortly. So he places the matter after. Is it together with WC 287 or 2025? Yes. They are allowed list together with 2 on the next date. Yes.
Much obliged.
That VPP matter, you see, you look up, you do some research in election law. It's very difficult. You can't maintain it.
Yeah,
Election
yes.
law is a different thing altogether. It's not a question of you filing a PIL or something. It's not like that.
There's a specific rule, that I'll just point that rule down.
But SCP, Your Lordship, after regularization later part.
No,
and
we just talk
SCP
about something else. Other matters is there.
Oh,
Yes.
yes.
Quite interesting. Yes.
Much.